Art. 12. Circumstances which exempt from criminal liability. The following are exempt from criminal liability. 1. An imbecile or insane person, unless the latter has acted during a lucid interval. When the imbecile or an insane person has committed an act which the law defines as a felony, delito, the court shall order his confinement on one of the hospital or asylums established for persons thus afflicted. He shall not be permitted to leave without first obtaining the permission of the same court. Requisites. Offender as an imbecile offender was insane at the time of the commission of the crime. Imbecility or insanity. An imbecile is exempt in all cases from criminal liability. The insane is not so exempt if it can be shown that he acted during a lucid interval. In the latter, loss of consciousness of one's acts and not merely abnormality of mental faculties will qualify one's acts as those of an insane. Procedure. Court is to order the confinement of such persons in the hospitals or asylums established. Such persons will not be permitted to leave without permission from the court. The court, on the other hand, has no power to order such permission without first obtaining the opinion of the DOE that such persons may be released without danger. Presumption is always in favor of sanity. The defense has the burden to prove that the accused was insane at the time of the commission of the crime. For the ascertainment such mental condition of the accused, it is permissible to receive evidence of the condition of his mind during a reasonable period both before and after that time. Circumstantial evidence which is clear and convincing will suffice. An examination of the outward acts will help reveal the thoughts, motives and emotions of a person and if such acts conform to those of people of sound mind. Insanity at the time of the commission of the crime and not that at the time of the trial will exempt one from criminal liability. In case of insanity at the time of the trial, there will be a suspension of the trial until the mental capacity of the accused is restored to afford him a fair trial. Evidence of insanity must refer to the time preceding the act under prosecution or to the very moment of its execution. Without such evidence, the accused is presumed to be sane when he committed the crime. Continuance of insanity which is occasional or intermittent in nature will not be presumed. Insanity at another time must be proved to exist at the time of the commission of the crime. A person is also presumed to have committed a crime in one of the lucid intervals. Continuance of insanity will only be presumed in cases wherein the accused has been adjudged insane or has been committed to a hospital or an asylum for the insane. Instances of insanity. Reus. Feeble-mindedness is not imbecility because the offender can distinguish right from wrong. An imbecile and an insane to be exempted must not be able to distinguish right from wrong. Relova. Feeble-mindedness is imbecility. Crimes committed while in a dream, by a somnambulist are embraced in the plea of insanity. Hypnotism, however, is a debatable issue. Crime committed while suffering from malignant malaria is characterized by insanity at times, thus such person is not criminally liable. Basis. Complete absence of intelligence, and element of voluntariness. Definition. An imbecile is one who while advanced in age has a mental development comparable to that of children between 2 and 7 years of age. An insane is one who acts with complete deprivation of intelligence, reason or without the least discernment or with total deprivation of freedom of the will. Dementia praecox is covered by the term insanity because homicidal attack is common in such form of psychosis. It is characterized by delusions that he is being interfered with sexually, or that his property is being taken, thus the person has no control over his acts. Kleptomania or presence of abnormal, persistent impulse or tendency to steal, to be considered exempting, will still have to be investigated by competent psychiatrist to determine if the unlawful act is due to the irresistible impulse produced by his mental defect, thus loss of willpower. If such mental defect only diminishes the exercise of his willpower and did not deprive him of the consciousness of his acts, it is only mitigating. Epilepsy, which is a chronic nervous disease characterized by convulsive motions of the muscles and loss of consciousness, may be covered by the term insanity. However, it must be shown that commission of the offense is during one of those epileptic attacks. 2. A person under 9 years of age. Minority under 9 years to be construed 9 years or less. Such was inferred from the next subsequent paragraph, which does not totally exempt those over 9 years of age if he acted with discernment. Presumptions of incapability of committing a crime is absolute. Age is computed up to the time of the commission of the crime. Age can be established by the testimonies of families and relatives. Senility or second childhood is only mitigating. 4 periods of the life of a human being. Requisite. Offender is under 9 years of age at the time of the commission of the crime. There is absolute criminal irresponsibility in the case of a minor under 9 years of age. Basis. Complete absence of intelligence. Age. Criminal responsibility. 9 years and below absolute irresponsibility. Between 9 and 15 years old conditional responsibility without discernment. No liability with discernment, mitigated liability. Between 15 and 18 years old mitigated responsibility. Between 18 and 70 years old full responsibility. Over 70 years old mitigated responsibility. 3. A person over 9 years of age and under 15, unless he has acted with discernment, in which case, such minor shall be proceeded against in accordance with the provisions of Article 80 of this Code. When such minor is adjudged to be criminally irresponsible, the court, in conformity with the provisions of this and the preceding paragraph, shall commit him to the care and custody of his family, who shall be charged with his surveillance and education. Otherwise, he shall be committed to the care of some institution or person mentioned in said Article 80. Qualified minority. Basis. Complete absence of intelligence. Such minor over 9 years and under 15 years of age must have acted without discernment to be exempted from criminal liability. If with discernment, he is criminally liable. Presumption is always that such minor has acted without discernment. The prosecution is burdened to prove if otherwise. Discernment means the mental capacity of a minor between 9 and 15 years of age to fully appreciate the consequences of his unlawful act. Such is shown by 1. Manner the crime was committed, i.e. commission of the crime during nighttime to avoid detection, taking the loot to another town to avoid discovery, or 2. The conduct of the offender after its commission, i.e. elation of satisfaction upon the commission of his criminal act, as shown by the accused cursing at the victim. Facts or particular facts concerning personal appearance which lead officers or the court to believe that his age was as stated by said officer or court should be stated in the record. If such minor is adjudged to be criminally liable, he is charged to the custody of his family, otherwise, to the care of some institution or person mentioned in Article 80. This is because of the court's presupposition that the minor committed the crime without discernment. Allegation of with intent to kill, in the information is sufficient allegation of discernment, as such conveys the idea that he knew what would be the consequences of his unlawful act. Thus is the case wherein the information alleges that the accused, with intent to kill, willfully, criminally and feloniously pushed a child of 8.5 years of age into a deep place. It was held that the requirement that there should be an allegation that she acted with discernment should be deemed amply met. 4. Any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. Accident. Basis. Lack of negligence and intent. Elements. Discharge of a firearm in a thickly populated place in the city of Manila being prohibited by Art. 155 of the RPC is not a performance of a lawful act when such led to the accidental hitting and wounding of 2 persons. Drawing a weapon, gun in the course of self-defense, even if such fired and seriously injured the assailant, is a lawful act and can be considered as done with due care, since it could not have been done in any other manner. With the fact duly established by the prosecution that the appellant was guilty of negligence, this exempting circumstance cannot be applied because application presupposes that there is no fault or negligence on the part of the person performing the lawful act. Accident happens outside the sway of our will, and although it comes about some act of our will, lies beyond the bounds of humanly foreseeable consequences. The accused, who, while hunting saw wild chickens and fired a shot, can be considered to be in the performance of a lawful act executed with due care and without intention of doing harm when such shot recoiled and accidentally wounded another. Such was established because the deceased was not in the direction at which the accused fired his gun. The chauffeur, who while driving on the proper side of the road at a moderate speed and with due diligence, suddenly and unexpectedly saw a man in front of his vehicle coming from the sidewalk and crossing the street without any warning that he would do so, in effect being run over by the said chauffeur, was held not criminally liable, it being by mere accident. A person is performing a lawful act exercise of due care, he causes injury to another by mere accident without fault or intention of causing it. 5. Any person who acts under the compulsion of an irresistible force. Irresistible force. Basis. Complete absence of freedom, an element of voluntariness. Elements. Force, to be irresistible, must produce such an effect on an individual that despite of his resistance, it reduces him to a mere instrument and, as such, incapable of committing a crime. It compels his member to act and his mind to obey. It must act upon him from the outside and by a third person. Bikuli, who was accused but not a member of a band which murdered some American school teachers and was seen and compelled by the leaders of the band to bury the bodies, was not criminally liable as accessory for concealing the body of the crime. Bikuli acted under the compulsion of an irresistible force. Irresistible force can never consist in an impulse or passion, or obfuscation. It must consist of an extraneous force coming from a third person. That the compulsion is by means of physical force. That the physical force must be irresistible. That the physical force must come from a third person. 6. Any person who acts under the impulse of an uncontrollable fear of an equal or greater injury. Uncontrollable fear. Basis. Complete absence of freedom. Elements. That the threat which causes the fear is of an evil greater than, or at least equal to that with he is required to commit. That it promises an evil of such gravity and imminence that the ordinary man would have succumbed to it. Duress, to be a valid defense, should be based on real, imminent or reasonable fear for one's life or limb. It should not be inspired by speculative, fanciful or remote fear. Threat of future injury is not enough. The compulsion must leave no opportunity to the accused for escape or self-defense in equal combat. Duress is the use of violence or physical force. There is uncontrollable fear as when the offender employs intimidation or threat in compelling another to commit a crime, while irresistible force is when the offender uses violence or physical force to compel another person to commit a crime. An act done by me against my will is not my act. 7. Any person who fails to perform an act required by law, when prevented by some lawful or insuperable cause. Lawful or insuperable cause. Basis. Acts without intent, the third condition of voluntariness in intentional felony. Elements. That an act is required by law to be done. That a person fails to perform such act. That his failure to perform such act was due to some lawful or insuperable cause. Examples of lawful cause. To be an exempting circumstance. Intent is wanting. Intent presupposes the exercise of freedom and the use of intelligence. Distinction between justifying and exempting circumstance. Priest can't be compelled to reveal what was confessed to him. No available transportation. Officer not liable for arbitrary detention. Mother who was overcome by severe dizziness and extreme debility, leaving child to die, not liable for infanticide. Exempting. There is a crime but there is no criminal. Act is not justified but the actor is not criminally liable. General rule. There is civil liability. Exception. Par 4, causing an injury by mere accident, and Par 7, lawful cause. B. Justifying. Person does not transgress the law, does not commit any crime because there is nothing unlawful in the act as well as the intention of the actor. Distinction between exempting and justifying circumstances. Exempting circumstance. Justifying circumstance. Existence of a crime. There is a crime but there is no criminal. The actor is exempted from liability of his act. There is no crime. The act is justified. Absolutary causes are those where the act committed as a crime but for some reason of public policy and sentiment, there is no penalty imposed. Exempting and justifying circumstances are absolutary causes. Other examples of absolutary causes. 1. Art. 6. Spontaneous desistance. 2. Art. 20. Accessories exempt from criminal liability. 3. Art. 19. Par 1. Profiting oneself or assisting offenders to profit by the effects of the crime. Instigation versus entrapment. Instigation. Entrapment. Instigator practically induces the would-be accused into the commission of the offense and himself becomes co-principal. The ways and means are resorted to for the purpose of trapping and capturing the lawbreaker in the execution of his criminal plan. Accused will be acquitted. Not a bar to accused's prosecution and conviction. Absolutary cause. Not an absolutary cause. Mitigating circumstances. Definition. Those circumstances which reduce the penalty of a crime. Effect. Reduces the penalty of the crime but does not erase criminal liability nor change the nature of the crime. Kinds of mitigating circumstance. Privileged mitigating. Ordinary mitigating. Offset by any aggravating circumstance cannot be offset by any aggravating circumstance can be offset by a generic aggravating circumstance. Effect on the penalty has the effect of imposing the penalty by 1 or 2 degrees than that provided by law. If not offset, has the effect of imposing the penalty in the minimum period. Kinds: minority, incomplete self-defense, 2 or more mitigating circumstances without any aggravating circumstance, has the effect of lowering the penalty by 1 degree. Those circumstances enumerated in paragraph 1 to 10 of Article 13.